and protecting your pregnancy-related disability claim. Welcome back to Winning Isn't Easy. Now, when you are filing a short-term disability claim during pregnancy, uh, there are some things you need to do that can really impact ultimately the payment of your claim. When you file a claim based on pregnancy, you need to be prepared to submit detailed medical documentation. This should include your expected due date, any medical restrictions, particularly with lifting limitations, traveling, bed rest orders. Number three, any pregnancy-related complications you might be having. So you might, for example, have issues with gestational diabetes. Next, your anticipated time off from work. So those are the sort of the general things that you want to be discussing in the application. It will take several weeks for the insurance company or plan to process and approve a claim. So don't wait until the due date approaches. You want to get the paperwork in, I think, at least 4 to 6 weeks before you expect to go on leave, or earlier if your doctor anticipates complications. Now remember, some policies only provide benefits for postpartum recovery unless medical issues justify leave before birth. Others will require that you meet specific eligibility timelines related to when your policy began. Again, you got to get out that policy or plan and read it cover to cover. When should you contact a disability attorney? Now, if your employer denies your right to take leave under the Family Medical Leave Act, or if you're being discriminated against because you're pregnant, it might be time to talk with both an employment attorney and a disability insurance attorney. Don't do FMLA or employment litigation, and I routinely refer these types of issues to my local employment attorney with whom I have a really great referral relationship. But you would want to consult a disability attorney also if the carrier is denying your claim due to exclusions for pre-existing conditions or policy timing issues. Your insurer questions whether your doctor's restrictions are valid. You miss paperwork deadlines or are accused of non-compliance with medical care. So what we disability attorneys can do is really to review the policy or the plan, review your medical records, and then review the denial letter or request for information that you're getting from the disability carrier or plan to understand what the limits are here. Limits in terms of what does the policy provide, what do you have to prove, what are they saying you haven't proven or provided, are there any non-compliance issues, are there any pre-existing condition issues. So obviously it's important that all of that be done to determine your legal rights and whether you have a valid appeal to challenge a wrongful denial or termination of benefits. Clearly, the involvement of an attorney can make a difference in the outcome of your claim and any necessary appeals. But what happens then if your claim is denied, and how will the attorney assist? Well, if the claim is denied, you typically have the right to file what's called an internal appeal directly with the insurance company or plan. Now, what I do is I assist my clients, as I said, in understanding why the claim was denied in the context of the policy or the plan. We identify gaps or weaknesses in the medical documentation, and we prepare an appeal with additional evidence and legal arguments. Now, most insurers, companies in the short-term disability world will be responding within 30 days. And again, it depends on the terms of the policy or the plan. But we also need to understand that an appeal has to be filed. If you don't file an appeal, you may not be able to litigate the case. Your attorney might suggest that a lawsuit be filed after an appeal, just for the purposes of bringing them to the table to talk about resolving the case. Appealing the denial can be complex, and I find that disability carriers can rely on vague policy language or incomplete medical records to create a reason to deny a claim, much as they did in the story that I told you about my pregnant client who, after delivery, had a stroke. So we developed a strategy to help overcome this denial. We weren't successful in federal court at the district level, but the case was taken to the 11th Circuit Court of Appeals. because we felt strongly that the district court was wrong. And ultimately, the 11th Circuit Court of Appeals agreed with us. But we created a strategy that gave her ultimately the best chance of reversing that denial, and we were successful. Pregnancy cases can be very complicated, and also complicated because of the language and limitations in the policy or plan. Got it? Let's take a break.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos that will assist you in submitting a winning disability application. This is one you don't want to miss. For the next 24 hours, we're giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.